Without further ado, I want to welcome everybody to CCI North Alberta's webinar on condo security. My name is Alan White. I'm the Executive Director for CCI North Alberta. At least I was before we started this webinar. Before I introduce our presenters for today, I just want to thank our sponsors for today's event. We have BFL Canada Insurance Services, as well as Keller Engineering. We thank them for their support, not only for the webinar today, but for their support throughout our year end. So for today's webinar, just to let everybody know, we have everybody on mute. Questions can be asked through the Q&A section that's located at the bottom of your screen. We'll do our best to get to as many questions as we can. We've expanded the time today to allow for more questions. However, with the caveat that we want to make sure that the questions that are being asked are pertinent to today's webinar. I know anytime you get a lawyer and a police person in the room, you want to ask a myriad of different questions, but we got to focus on the task at hand for today. Beverly, if you want to put the poll question out, and I'll introduce our next presenter at the same time. So the question we're asking is, does your corporation have a privacy officer and a privacy policy? We'll let that go on. So our second portion here is going to be talking more specifically in terms of privacy issues with PIPA and surveillance cameras. We're very pleased to have Erin Berney from a condominium lawyer with Field Law. Erin is also a condominium owner. She's been an owner since 2005 and has served on her board in a variety of different positions. She was admitted to the bar in 2013, and currently her primary focus is condominium law, where she assists corporations, boards, owners, tenants, managers, and developers on a broad scope of issues. In her spare time, Erin enjoys reading a good book, playing golf, piano, and guitar, very multi-talented, as well as spending time with her family, friends, and her cat, Winston. So Erin, just before I turn it over to you, we'll just share our results on the question, does your corporation have a privacy officer and a privacy policy? Neither has, 33% of the people have stated they have neither. Privacy officer only is 14%. Privacy policy only is 8%. Yes to both is 22%, and unsure of their corporation is 23%. So thank you very much for everybody for answering. And now, without further ado, Erin, I will turn the presentation over to you.
Thank you, Alan. Hi. So that's interesting responses, because one of the things I'm going to be talking about today is the requirements under the Alberta Personal Information Protection Act and how they apply to condominium corporations. And two things in there jump out at me. Number one, organizations, including condominium corporations, are actually required to have privacy policies in place. And they're also required to have privacy officers, or a designated person that will deal with personal information that they control. So, just jumping into this. So the PIPA, as it's called, the Personal Information Protection Act, does apply to condominiums. So condominiums are actually required to follow a certain set of prescribed conditions in order to collect, use, and disclose personal information belonging to individuals that access their building. This can include owners, tenants, other residents, even contractors, personnel, employees, but anybody that comes and goes into your building. So PIPA, however, does not apply to individuals. It only applies to organizations. So this imposes a positive duty on condominium corporations to protect the personal information of their residents and other people that they collect. One of those responsibilities is that condo corporations are only allowed to collect, use, and disclose for purposes that are considered reasonable and only to the extent necessary and reasonable for that particular purpose. What is reasonable, of course, will always vary depending upon the circumstances. PIPA prohibits organizations from collecting, using, and disclosing personal information without first acquiring consent from the individual, unless you can find an exception for obtaining consent under PIPA itself. So there's certain sections that you can look at that set out a variety of different circumstances where consent would not be required. One example is where an owner is required to provide personal information pursuant to the provisions of the Condominium Property Act. One thing that jumps to mind is the notice requirement whenever the owner changes their address. They are required to provide an address for service to the condo corporation. Another one would be where the condo corporation chooses, where the owner chooses to rent out his or her unit. He or she is required to provide the names of the prospective tenants that are going to be living in that unit. But if you can't find an exception for consent, then the organization is required to obtain it. However, while consent can be obtained orally or in writing, there are also situations in which consent can be deemed. For example, where the individual has voluntarily provided the personal information to the organization, and it is considered reasonable in the circumstances that a person would provide that information. So another important point to take here is that whenever you are collecting, using, or disclosing personal information belonging to an individual, an organization is required to provide that individual with notice. The notice must also include the purpose for the collection, use, or disclosure, and provide a name of the person at the organization who can answer questions about the collection. So namely, your privacy officer. This would be somebody, likely a board member that you have designated to be that go-to person. So the purpose doesn't necessarily need to be stated in the notice if it can be reasonably inferred from the notice itself. And here my example is video cameras being posted at front entrances. As Constable McKinnon described, video cameras are so ubiquitous these days that I think it's reasonable, and courts have agreed, that people who approach a building and see such a notice that, you know, this building is under video surveillance, that you can reasonably infer that the purpose is for promoting security or enhancing security and preventing theft, vandalism, and other mischief in the building. So with respect to video surveillance specifically, in Alberta, this issue's come up before the Privacy Commissioner only a few times, actually, with respect to condominium corporations, which I found strange, but it is what it is. So this was back in 2006. The Privacy Commissioner first determined that personal information of individuals, as it's defined under the Personal Information Protection Act, is being collected through video surveillance when the image of that individual is recorded on a digital hard drive or videotape. So this means that, yes, when you install video surveillance in your buildings, you are in fact recording people's personal information. So you are collecting that personal information. And as such, the provisions in PIPA apply. Condominium corporations, according to the Condominium Property Act, they're statutorily responsible for the control, management, and administration of all of the corporation's real and personal property and of all common property. This actually is what allows condo corporations to be able to install video surveillance cameras because of that oversight, because of that responsibility. So they can do this as long as they've provided their residents with the proper notice. The reason for this is because individuals have a diminished expectation of privacy in those common areas, such as hallways, stairways, entrances, elevators, even parkades to a certain extent, especially if the cameras themselves are visible and proper notices have been posted that are prominent, advertising of the camera's existence and locations. It was actually a Court of Appeal decision in Ontario that first determined that this was acceptable. And in that case, the court also determined that a condominium corporation was permitted to hand over video footage from common areas to police when requested to do so, when police were investigating a crime. And they can do that without first obtaining consent from the residents. So in Alberta, there's been really just one decision that actually addressed video surveillance by a condominium corporation, and this was the Grandin Manor case. This was back in 2016. In that case, an owner had objected to the use of video footage to investigate an alleged bylaw violation against him, and he made a complaint to the privacy commissioner for that reason, but also complaining that the number of cameras was excessive, the positioning of the cameras was intrusive, and that he had not provided consent, and a host of other complaints, actually. So the case considered the use of surveillance systems installed in the common areas. And it found, of course, that according to PIPA, residents and visitors must have notice of the existence and location of the security cameras. In this case, notices were posted at entrances, and moreover, they actually had an image of a camera, which the commissioner found benefited non-English speaking individuals who would, go in and out of the building. So it might not be enough in some circumstances to just have an English description saying, video surveillance, you are being recorded. A picture of a camera, I think, is crucial. So these notices were found sufficient in order for the commissioner to find that consent of the residents and all users of the building could be deemed. Moreover, they found the Condominium Corporation brought forth evidence from their last annual general meeting. They produced the minutes of that meeting showing that there had actually been a vote of the owners, an ordinary resolution, whereby the owners had overwhelmingly approved the addition of video cameras and the number of cameras that were installed in their building. So that was further evidence of them having given consent. The purpose of the video surveillance or collection of personal information, as stated in the notice, was to deter vandalism and promote security. So the privacy commissioner determined that the corporation was entitled to review the camera's footage in order to investigate any security incidents or criminal events when and if they occurred. However, what the corporation had done in this case was send a warning letter to the unit owner who had complained because they had reviewed footage of him scribbling on a notice board in the common area. And they claimed that constituted a bylaw violation, which they were warning him about. And if he continued doing that, then they intended to fine him. Unfortunately for the corporation, this was not among the stated purposes. This was not an inferred purpose or that could be inferred from the notices that were posted. And this was not something that was discussed by the owners or put to the owners during the AGM. So the corporation could not use the footage to pursue a bylaw violation the way they were doing it. So in summary from that case, we can take from it that anybody who enters your building and sees posted signs alerting of the presence of video cameras and video surveillance, and they choose to enter the building notwithstanding those signs, can be deemed to have provided their consent for the collection of their personal information. That's what voluntary provision of personal information, it's deemed consent. But any other purpose aside from security, promoting security, reducing vandalism, etc., must or should be stated in the notice itself. So if you intend to use video surveillance to pursue bylaw violations, then that needs to be properly stated in the notice. So in an earlier case back in 2006 again, they found that signs notifying individuals of general surveillance in common areas was sufficient, that signs need not specify the reason or use as long as it's reasonably clear from the context, preventing theft, vandalism, mischief. But if you're going to go further than that, like for bylaw violations or for acts of tenants or something like that, then that needs to be stated. Okay, so one of the things that's come up in the past couple of years is the existence of doorbell cameras, and those have been really increasing in popularity. More and more I've seen requests from residents to install doorbell cameras on their front door or to install some form of video surveillance on the exterior of their unit. when that happens, PIPA can still be engaged, which could trigger the condo corporation's duties, especially in a circumstance where the common property is involved. So doorbell cameras, in one case out of BC, have actually been found to be considered alterations of the common property. And most condo owners and property managers would recognize that alterations are typically included as provisions in the bylaws, that owners and residents are not permitted to alter the common property without consent or permission from the board. So of course, consent needs to be obtained first. This particular case was a strata or a condo in Whistler, BC. It was a mixed 4-story complex. Some of the issues that the tribunal considered was whether the owner required permission in the first place. He was, of course, arguing that it was merely an addition, not an alteration. The court disagreed. He was likening the camera to the existing peephole in his front door or to a cell phone camera. Again, the court disagreed. The tribunal ultimately found that by requiring the owner to remove the doorbell camera, the Strata Corporation was acting within its authority under its bylaws and under provincial legislation in British Columbia, which is comparable to here, but not identical, because it was attached to the common property. In this case, it was, if you consider the difference between a traditional condo and a bare land condo, where traditional condos, doors and windows on the exterior of the unit are generally speaking common property. So they are the responsibility of the corporation to repair, maintain, replace, and they are also under the jurisdiction of the condo corporation whenever any alterations are being contemplated. So that decision was followed by a decision called Hare, also in BC. Oddly, I haven't seen any doorbell camera cases outside of BC. It's interesting. But in this case, it was a tenant that had installed a video recording device on the exterior door through the existing peephole without first obtaining approval, and the corporation ordered him to remove it. The tenant was arguing that the layout of the building should affect the outcome of the case because the way that his door faced, he wasn't, you couldn't see any other entrances, you couldn't see any other owners' units or people coming and going. The court disagreed. They said building layout is irrelevant. The issue is the fact that this is installed on common property and it was done without permission. And the purpose was, as the tenant himself stated, to improve security. The tenant, I guess, had been experiencing some harassment or alleged harassment from another resident, and argued that the court should take that into account in allowing him to keep his camera. The court disagreed again and found that this did not reduce the strata or did not undermine the Strata Corporation's decision or make it unreasonable, because the Strata Corporation had to consider its obligations under BC's version of PIPA, and also consider the potential impact of the tenant's camera on the privacy of all residents of the corporation. And it had properly done so in this case by asking the tenant to remove the camera. It's important to note, however, here that BC's legislation is slightly different than Alberta. This legislation varies from province to province. So what's okay here may not be okay in Ontario and vice versa. In BC, their version of PIPA actually prohibits strata corporations from placing any video surveillance cameras on common property unless that strata corporation's bylaws expressly allow for video surveillance and the residents are first notified. In the case I just mentioned, Hare, the strata's bylaws also did not even permit video cameras on the common property. So to go even further, the strata corporation was within its authority to demand that the tenant remove the camera because they weren't even permitted under the bylaws. So taking from these cases that I've developed sort of a set of best practices for condo corporations and for unit owners alike. Number one being that corporations need to develop a privacy policy. Again, I stress this is actually a requirement under PIPA. You must have a privacy policy. And this should set out things such as what kind of information will be collected and what will it be used for. So your examples, these are your purposes. Examples being security, enhancing security, deterring vandalism, deterring crime, But if you also intend to use that footage at any time to pursue a bylaw violations or actions against residents for improper conduct, then you need to state that purpose as well. And that should be spelled out in your policy as well as set out in any notices to residents, such as the ones posted throughout the building. But it should also be brought up at your annual general meeting. Give owners an opportunity to vote on and determine that this is what they want to allow. Second thing is who will be permitted to access this information. Again, I mentioned the need to have a privacy officer designated who is going to be the one person who will actually view the footage. The entire board should not have access to the footage. Only the privacy officer should be allowed to view the footage or should be allowed to permit to view the footage with police or potentially with the property manager. There are some front entrance cameras that have live feeds that are accessible by all residents. I believe that should be discouraged because you can't control that information anymore. The corporation, it's not within your control. Any owner could potentially record that footage and use it for whatever purpose. So that's the reason why it should not be, live feeds are not a good idea. Another thing is how long is the information going to be retained? PIPA requires organizations to only keep the information for as long as reasonably necessary for the purpose for which it was collected, and then thereafter organizations are required to destroy that information. So if you're using it for building security or bylaw violations, consider maybe only keeping it for a couple of days or a week, and then having it be recorded over. Another thing is having the information be kept in a secure location, whether that's on site or off site, but it has to be kept in a room that's locked, that's only accessible by the privacy officer, so that it can be kept secure. Finally, how are requests for access to the information by residents going to be treated? You have to have a policy around that as well, because PIPA specifies that any individual can make a request to the organization to access their information at any time. When the organization receives such a request, it has to provide a response within 45 days. And the response must disclose who has seen this information, who it's been used by, and for what purpose. So as I said, just to kind of recap, you want to state the purpose for the surveillance cameras on any notices that are posted at entrances. You want to try and obtain owner approval at AGMs and record the result of any votes in the minutes for that meeting. You want to appoint a privacy officer, and then you want to communicate this to residents. Once you have your policy in place and your officer appointed, you want to make sure that residents know who to contact. For resident security cameras, residents who want to install security cameras, the goal should be to minimize the privacy intrusion on other residents. I don't believe that it would be a good practice for condo corporations to simply deny all such requests or to have a policy in place that they will not permit these in any circumstances. Wherever there is discretion in your bylaws, such as making alterations to common property, and there typically is, corporations are required to exercise that discretion in a reasonable way, which means not arbitrarily refusing such requests. So with each request, you have to consider it and provide a reasoned response, either yes or no, as to why they can or cannot have that camera. For permitting such cameras, your policy should detail that first a request for approval is required, that the board will consider these requests, and give information about what the owner or resident will have to provide with that kind of request. For example, maybe getting a still image of the potential camera's footage to determine its field of view and what it's actually collecting. You'll want information about how this thing is activated, how long images are stored, whether it records at all, or whether it just live feeds to a cell phone, for example. So I'm just gonna flip. Your policy on residents installing security cameras on the common property should also probably notify other adjacent residents that there has been such a request and allow them an opportunity to respond, to object to it. You want to consider the location of the camera, the direction it's facing, and what areas they're actually capturing. And for residents, number one, make the request. Make sure that you obtain consent, because if you do not, then that's grounds for the condo corporation to require you to remove it or to remove it themselves. Okay. I guess one other thing is the board should consider if the camera can be installed without damaging the common property, installed and then removed later without damaging the common property. Failing which, you might want to consider getting an undertaking from that owner that any damage they cause, they will be responsible for. Just another tip I just thought of. Okay, and that's about it in a nutshell.
Thank you very much, Erin. Lots to digest in there, and I can tell by just the volume of questions we're getting in, it is a topic of much discussion that way. Beverly, you had a quick poll question that we'll do just before we'll start doing the Q&A with Erin. And the question is, does your complex currently use surveillance cameras? Very simple. Just one additional point Erin had made regarding the privacy policy. At our website in the Resource Center, we actually have a template of a privacy policy that Service Alberta put out, which has the basic guts of a privacy policy, and then it allows the corporation to put in the details as it pertains to their particular complex. So you'll find that in the Resource Center on the CCI North Alberta website. So the results of our poll: does your complex currently use surveillance cameras? This is a surprise to me. 61% said yes, 37% said no, and 2% weren't sure if the cameras were there or not there. So thank you very much. So Erin, we'll start with some of the questions here. Somebody just wanted clarification what you meant by PIPA does not apply to individuals.
Okay, so the obligations that are set out under the provincial legislation only apply to organizations. Organizations are required to comply with them. Organizations are required to have these policies in place and use these practices. Individuals who use video surveillance, like on cell phone cameras or otherwise, are not subject to those requirements whatsoever. But however, like I said, when an individual is using is installing a video camera on common property that is under the care and control of the corporation, then the corporation's duties under PIPA might be engaged.
Okay. Next question, can a condo board collect and store information about the comings and goings of people with access via a fob entry system?
Yes, that's another way that personal information can be collected, because you'll have your fobs, you'll have your fobs numbered and assigned to residents. So that data would be collected and potentially stored someplace. You'll need to have a policy concerning that as well. It's no different, I think, than video surveillance footage recording the comings and goings in visual images. So.
Yeah, I'd be struggling to see the reasoning behind trying to track people coming and going at a time, but there may be isolated cases where that may play, I guess. Next question is it allowed to say that a property may be under surveillance when it may not be? What legal liabilities come from this statement?
I think that potentially gives residents a false sense of security. If you're saying it may be under video surveillance, or say, for example, I've seen instances where people say you are under video surveillance when in fact you're not, and they've posted fake cameras in locations. Yeah, I think I haven't examined that issue in much detail, but I think it could potentially attract some liability for a condo corporation that does that.
Yeah.
So
I would definitely agree on that, over the old overpromise and underdeliver. Yeah. A question come in that's kind of an open-ended question, but see if you can put some clarity to it. Would you advise condo management to post pictures from CCTV of individuals? I would assume this is in the case of and I guess maybe that's the question, is when would that be appropriate?
I think it would only be appropriate in the case of a criminal investigation, for example, a break-in situation, where you've recorded images of people entering the building or entering a parkade and stealing bicycles, for example, or vandalizing vehicles, and you don't know who they are and you're trying to identify them. I think it'd be permissible in those circumstances, but again, going back to the purpose for which you collected the information in the first place, I think that is important. If your purpose is to investigate bylaw violations, then it's potentially permissible to post images of somebody engaged in a bylaw violation where there's no corresponding criminal investigation. But I would be very careful in that case. So.
Okay. After the installation of cameras, could a corporation notify the owners that video footage would also be used for bylaw or policy infractions? And I guess a follow-up to that would be, would it be best handled through an ordinary resolution at a general meeting, or can a corporation just after the fact say that we're now collecting information for bylaw infractions as well?
Well, I think that doing it after the fact is never a good idea. I think if you're but if yes, let's say you already have video cameras installed and you want to clarify your purposes, then first thing you do need to provide your owners with notice. As a good idea, I recommend transparency, and I recommend giving owners the opportunity to give feedback. And potentially vote on whether or not they think that that's a legitimate purpose or a legitimate use for those security cameras. So it may be a good idea after you've provided that notice to residents to include that on your agenda for the next at the next annual general meeting, and give owners a chance to vote on it. Okay.
If we have cameras, should we have signs showing and stating where the cameras are?
That actually, it does help when trying to ascertain whether or not consent has been deemed, whether the person captured on the footage has voluntarily provided this information. If you can't see the cameras and you can't see the notice, then it's meaningless, and I don't think that you can infer consent from that. I think if the cameras are visible, the more visible the cameras are, and the more visible and prominent the notices are, then the better off the corporation is in terms of defending itself against any complaints down the road.
Okay. We've had a couple of questions regarding the scenarios that have been brought up, like case law and that, have been more apartment-style buildings. So does anything change when we're talking about a townhome complex as opposed to apartment-style building when it comes to security cameras?
Well, again, I think it depends on the type of condominium, not necessarily the building layout, but the type, whether we're dealing with a traditional or a bareland condo.
Bareland, yeah.
If it's a bareland condo and an owner has decided to install a video surveillance on the exterior of their unit, which is part of their unit, it's not common property, then that should be within their right, provided that their video camera isn't overly intrusive into the privacy of their next door neighbors, for example. But their next door neighbors' recourse might be through a complaint to the board in nuisance, or through the catch-all bylaw provision, like use of a unit that unduly interferes with an owner's use and enjoyment of their unit. So you got to consider other potential bylaw infractions when an owner puts up a video camera. In a traditional condo, on the other hand, where an owner has installed video surveillance on the exterior of the unit, that part is the exterior of the unit is common property. So that engages the corporation's duties, and that engages the right of the corporation to provide approval, and the corresponding necessity of the owner to have first obtain consent.
All right, we just got we're almost out of time here. I've got two more questions here. One, if bylaws require board permission to alter common property, can the board enact a blanket rule that permits doorbell cameras on hallway doors without individual unit owners having to seek permission?
That's similar to developing a policy, I suppose, but I don't think that a blanket permission should be granted. I think that each case should be considered separately by the board. I think that that's probably just a good habit to be in. You do want to make sure, because it is common property, the board is responsible for it, that these cameras that are being installed aren't damaging the common property, number one. So they're being installed in a safe and proper manner, and they are capable of being removed down the road without doing damage. And number two, that it's not going to unduly interfere with another resident, with their privacy or with their use of their unit.
Okay, last question. Should the privacy policy officer and policy be put into the bylaws, as bylaws are the only way to actually sanction or fine an owner?
I think that, like, what I've been doing when I'm drafting bylaws is I include a provision that the board will develop a privacy policy from time and may amend that policy from time to time. And violation of that privacy policy, thereby it gives you a bylaw provision that you can then use if the privacy policy is breached. So.
Okay. And sorry, I forgot one. Is audio recording permitted? Or is that another policy altogether?
I think that would be another policy altogether. I also don't see necessarily the utility in audio recording necessarily, because it doesn't, it's not as valuable in helping to identify somebody, which is the whole point, I think, of surveillance cameras, to be able to see who it was who did X or Y or Z. So yeah, I think that you would need a separate policy just to deal with audio. But unfortunately, I don't have any case law that talks about whether an audio recording of somebody is personal information. Because again, without doing like voice analysis, you can't determine that this voice was this person with any certainty or accuracy. So, yeah.
Very true, very true. But we did see your picture, so we know it was you that did the presentation.
Yes.
We've had a number of questions regarding the presentation itself. We will be sending everybody a link to the whole presentation that will have the slide and content on it. We'll also, there's been some questions regarding the sample privacy policy. We'll include the link to that part as well for people to view that. I want to thank both our presenters. Constable McKinnon had to leave for other duties there, so he's already gone, but I want to thank him and Erin for their great presentation today and all the detailed information. There's lots to absorb here. The beauty of having this recorded is that we can all take a look at our convenience and go through things and start following up on some of the things that we need to do within our corporation. So just before we go, I'll let you know we'll have a online survey of the seminar sent out to you tomorrow for feedback. Our apologies once again for the technical difficulties at the beginning. We did 2.5 dry runs and everything worked perfectly, and sure enough we get to the live event and everything goes to heck in a, well, you know what it is.